And what, when you were first contacted, or when your law firm was first contacted by homeowners, I mean, what was their I mean, it sounds like, to someone listening to Mr. Aaron, it sounds like the city went through, a very comprehensive process and came to a reasoned conclusion within the statute that this was an area in need of redevelopment, and they did their due diligence and did the proper studies. What were your clients? What were their dissatisfaction with the process?
Our clients came to us in 2005. 11 years after the process had begun, and they came to us because all of the sudden the original redevelopment plan that was adopted had their property listed as residential infill, which is a term that permits existing homes to remain in the redevelopment area. Thereafter, they looked at 3D scale models of the redevelopment project that showed their homes in it. And then, over the course of time, the city of Long Branch, without properly notifying our clients, changed the scheme. And all of a sudden, their assurances that they had been provided that their homes wouldn't be taken, the evidence that was shown by the city that their homes would be infill and shown as infill on 3D models, all of a sudden was no longer the case, and they were being condemned by the city. And so they came to us and said, the rules of the game have changed. Our properties were supposed to be saved, and now they're not. And so, hence the beginning of our struggle with the city.
And did they were these homeowners, were they involved in the planning board process from the beginning?
They were noticed of the planning board process at the original redevelopment plan, and some of the folks attended those meetings. What they weren't given proper notice of is the various amendments to the redevelopment plan that slowly over time changed the designation of their properties from residential infill to being able to be condemned and taken.
They weren't given any notice, or they weren't given enough notice?
They weren't given a notice that a layperson could understand as a threat to their property rights.
Okay, and I'm sure Mr. Aaron will have something to say about that when we come back from the break. But one more question. Was there an attempt to negotiate with the city at that point, or did you go straight to court?
Well, there were attempts to negotiate in the context of the condemnation actions to make sure that the homeowners were getting the appropriate amount of money for their property, but as well as negotiations to allow the property owners to keep their homes, but those negotiations failed.
Okay. We're going to go to a short break. Please stay with us for more about eminent domain and waterfront redevelopment in the city of Long Branch here on Outlook Monmouth.
When you open a book, you can explore new lands, meet new friends, and discover new adventures. There are amazing possibilities when you open your mind to reading. You can log onto the Library of Congress website and let the journey begin.
Hello, my name is Max Weinberg, and I'm a musician, but most importantly, I'm a parent. To best understand the challenges that our children face every day, well, I'm going to ask you to go back in time and remember the challenges that you faced as a child. How did you know what the right choice was? Prevention First is a nonprofit agency in Monmouth County that offers educational programs dedicated to strengthening the foundation of our children's lives.
Do you know that stroke targets by color? Odds are, if you're African American, you're twice as likely to suffer a stroke as white Americans. Know where you stand, because beating the odds isn't about winning, it's about living. Join the power to end stroke at strokeassociation.org.
Welcome back to Outlook Monmouth. I'm your host, Armin McCumber. If you're just joining us, we're talking about eminent domain and waterfront redevelopment in Long Branch. James Aaron is the city attorney for the city of Long Branch and the managing partner of the law firm of Ansell Zaro Grimm Aaron in Ocean, New Jersey. Christopher Healy is an associate with the law firm of Bathgate, Wegener Wolf in Lakewood, New Jersey. Together with Peter Wegener and Pamela Mada Snyder, Mr. Healy represents many of the homeowners who have been affected by waterfront redevelopment in Long Branch. So now we're back. The city's involved in litigation with a group of homeowners united against eminent domain and presumably the developers. Mr. Aaron, from the perspective of the city attorney of Long Branch, what were the issues that were litigated, and how did the court decide on the issues both before the Superior Court and the Appellate Division?
Well, basically, Armin, and thank you for the opportunity to respond. The city litigated the issue that was really before the court, and it was not really the issues that were brought up by the property owners originally. The structure of eminent domain changed when many years subsequent to the city's finding this area in need of redevelopment and the development actually moving forward. The case of Paulsboro case was looked at by the Supreme Court, and it put stricter standards on municipalities in how they arrived at the conclusion that areas that they designated to be in need of redevelopment were so found. And what the court said in the Long Branch case was, Long Branch, we want you to go back and revisit what you did roughly 11 years before to see if, in fact, it really met the standards, because we're not convinced from the reports and the resolutions and the record below that Judge Lawson did that appropriately, and we want you to go back. We order you to go back and do that. And take another serious look at it.
In terms of how you noticed, or in terms of how the city designated, or the planning board designated, these areas in need of redevelopment?
Two things. First, with respect to how the city determined the area was in need of redevelopment. And secondly, the right for the property owners to even challenge that designation 13 years later or 11 years later was given to the property owners by the court in the DeRose versus Jersey City and Hoboken cases, where the court said if a property owner's property is going to be taken through the redevelopment process, not the eminent domain process, but the redevelopment process, at the very beginning, when notices go out that the area is going to be studied, you need to tell them, A, your property rights will be affected. B, your property as a result of this designation could in fact be taken by eminent domain. And C, that you should have the absolute right to come in and challenge the city's right to use your property as part of this section. That was a new judicial activist opinion of the court that didn't exist in the pre-existing statute and hadn't been part of judicial decision making process before that time. So although the city didn't object to that, this decision really gave the property owners additional standing to come back and sue on the merits.
And Mr. Healy, you know, I'm an attorney. To me, that sounds a little unfair. It sounds like the court is going back in time and changing the rules and changing the standards. And it sounds like, you know, it's a little bit unfair to the city of Long Branch. What's your perspective on what the court decided?